You may be asking yourself, so what is HIPAA? The federal law known as HIPAA stands for the Health Insurance Portability and Accountability Act of 1996. Congress passed this landmark law to provide the following: portability of insurance, protection and privacy of healthcare information, standardization and efficiency in healthcare data, and prevention of discrimination and fraud. HIPAA gives the U.S. Department of Health and Human Services the responsibility of adopting rules to help individuals keep their personal health information private. HIPAA protects from unauthorized disclosure of any protected health information that pertains to the patient. It establishes a national set of security standards for protecting certain health information that is held or transferred in electronic form. In addition to privacy and security, administrative provisions were also included in HIPAA to improve the efficiency and effectiveness of the healthcare system. These include specific transaction standards and code sets, national standard and unique identifiers, and data security and electronic signatures. HIPAA compliance is highly dependent on the size, function, administration, and type of entity or business associate. Therefore, this training module is not intended to be a complete or comprehensive guide to HIPAA compliance. Entities and business associates regulated by the privacy and security rules are obligated to comply with all of their federal and state requirements and should not rely on this training alone as a source of legal information or advice. In addition to ensure compliance with HIPAA, covered entities and business associates should regularly perform a risk assessment to track access to protected health information and periodically evaluate the effectiveness of security measures put in place. They should also regularly reevaluate potential risks to protected health information. Who is mandated to follow HIPAA requirements? The HIPAA law applies directly to these groups called covered entities and business associates. They are healthcare providers, health plans, and healthcare clearinghouses, technology companies, and cloud service providers, or anyone that has access to personal health information. So what is a healthcare provider? Well, it's any provider of medical or other health services, or any organization or person who transmits any health information in electronic form. This includes organizations and individuals that provide bills or are paid in connection with services in the normal course of business. Some common examples include physicians, dentists, optometrists, nurses, mental health providers, radiology centers, chiropractors, psychologists, pharmacies, durable medical equipment providers, hospitals, ambulance companies, home health care workers, and social workers. A health plan is any individual or group plan that provides or pays the cost of healthcare, such as an insurance company, Medicare, or Medicaid. A healthcare clearinghouse is a public or private entity that transforms healthcare transactions from one form to another into a required format. An example of this would be an outside billing service that ensures all information transferred between a doctor's office and an insurance company complies with HIPAA. HIPAA applies to employers only to the extent that they somehow operate in one or more of these three groups. The same standards apply to covered entities in both the public and private sectors. If a company offers health care and treatment to employees on site, such as an on-site clinic, the employer would be covered entity and be required to follow HIPAA requirements. So what is a business associate? A business associate is any company or individual with access to protected health information, or EPHI. A business associate is required to have a risk assessment, training, policies, and procedures just like a covered entity. Some examples of a business associate are IT vendors, laboratories, call centers, court reporters, cloud providers, legal services, suppliers, and manufacturers with access to PHI or EPHI. Business associates are required to protect PHI at all times, just like a covered entity. They are required to notify covered entities of any potential and active data breaches. Business associates must comply with HIPAA requirements by signing a contractual agreement with the covered entity. This is called a Business Associate Agreement, or BAA. A BAA states that the business associate will only use the protected health information for proper purposes and will safeguard it from misuse. A business associate must also comply with all security requirements of the HIPAA regulation and will ensure administrative, physical, and technical safeguards are in place to protect PHI. If a business associate violates HIPAA, they are not only in violation of the contract with the covered entity, but in violation with HIPAA itself. They will be held accountable for the penalties for both types of violations. If a business associate uses subcontractors, The HIPAA law requires contractual agreements between them. The subcontractor is held to the same HIPAA requirements in the use of PHI. Thank you for taking the time today to educate yourself on just what is HIPAA.